Criminal misdemeanor application number 001 of 2025 arising out of Nakawa Criminal Court case number 08 of 2025 Uganda versus Dr. Kizza Besigye, Hajo Bedi Lutale.
May it please this honorable court worship. I am Jatiko Thomas, Assistant Director of Public Prosecution. I'm appearing together with my colleague, Richard, Chief State Attorney in this prosecution.
He's not part of the application. No. So what is it? No, I think we should sit. Then we need to put in
There's also a mention of that in the case.
Yes, but we're starting with the application.
Indeed.
So F3 shouldn't be part of them. You should sit. Yeah, you should.
Was in the corner there.
Or if there's a chair there, you can sit and, don't necessarily take part in this.
Worship, for the defense would humbly pray that my senior colleague, also Paco Arias, introduce the team, so we do not omit anybody.
May it please you, your worship. My name is Lukwago, appearing together with Mpanga. We have Farouk Kamlegea, Katumba Apollo, Sekanjako Abubakar, Bayan Tulinawe, and Ogul Science. proceed with the application, Your Worship.
For record, Your Worship. Billy from Kabiche, Chief State Attorney. For the applicant. Prosecution equally is ready to proceed for the applicant. However, last time when we appeared in court before, in respect to this matter, counsel for the respondent applied to this court to have Mr. Diek Benedict who deponed the affidavit for the applicant to appear in court we presume for cross-examination. And the court okayed it, Your Worship. However, Your Worship, it is a prayer by the prosecution that Mr. Diek Benedict, a police officer and one of the investigating officers in this matter, is a key person in these investigations, which are still ongoing. And is appearing before court, which has no jurisdiction to hear this matter substantively, but has jurisdiction to hear this application. My Lord, before this court, other press, it is for that reason, Your Worship, that prosecution, the applicant, prays to this court to have the application heard in chambers. This will ensure, one, protection of Mr. Odiek Benedict from public attacks. And threats which are imminent. Your Worship, this court is a witness. You can hear the singing and everything. So therefore, having Mr. Odiek before this court will jeopardize his security. As if that's not enough, it will jeopardize the investigations. because he's still one of the investigating officers in a matter whose investigations are still ongoing. Your Worship, under Article 28, Clause 2 of the Constitution of the Republic of Uganda, 1 and 2 actually. Allow me to read them verbatim. Under Article 28, Clause 1, Your Worship, it is stated that in the determination of civil rights and obligations or any criminal charge, a person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. And 2, that nothing in Clause 1 above of this article shall prevent the court, in this matter, this honorable court, or tribunal, from excluding the press or the public from all or any proceedings before it for reasons of morality, public order, or national security, as may be necessary in a free and democratic society. It is a submission, therefore, that our application passes the test under Article 28, Clause 2, to protect Ms. Zodiac and the integrity of the investigations. Given the nature of the offense and the people and the nature of the accused persons or applicants or respondents in this matter. This application is brought in good faith. It is brought in good faith, and in no way shall the rights of the respondents be prejudiced. And Your Worship, the Constitution provides the categories of people who can be excluded, and it says, our submission is that we exclude both the public and the press. This is not a substantive trial of the respondents. But even then, even in substantive trials, this court is enjoined with the powers to do away with the public and the press. Your Worship, protection of the witness or an investigating officer who will be a witness in the main trial at this stage is something that is paramount. And it is the duty of this court and all court officers of court to execute that role. There are other cases, Your Worship, when in the trial, for example, where courts have hinted on the importance of protecting witnesses and evidence at large. I'll not go into the details of that case, but I just want to quote it for your record. Your Worship, the constitutional reference number 6 of 2007 Sun Yen Kong Kim and another Sun S-O-S-O-O-N, Yen is Y-E-O-N, Kong is K-O-N-G, Kim and another versus Attorney General. My senior colleague Mpanga was part of that case, fortunately, but among the principles was a principle of protecting witnesses and the evidence we are held to be very, very critical. And Your Worship, it is our prayer that the reasons we have advanced are enough, Your Worship, to have this matter tried, heard in chambers. So,
Your Worship, in response, first of all, it is true that we were party and counsel in the Sun case, which the Land State Attorney has alluded to. What he hasn't told this court, and perhaps for reasons known to him, is that what was sought in that matter is what he was seeking, is what he's seeking now, and the Constitutional Court dismissed those arguments. The court found that the rights of an accused person are paramount. And Your Worship, the court took the view that in a criminal trial, the entire state causes its facilities to go down onto an individual, and that their rights cannot be compromised for the benefit of the state. And Your Worship, in that case, which again my colleague has referred to but has not told you the full facts, is that the court allowed a full disclosure of all material, including statements and the identity of the people who make statements, who essentially are the witnesses. Reason being that the accused person must be availed all facilities to prepare their defense. And that is in Article 28(2) C. Your Worship, it reads, at 28(3)C, every person who is charged with a criminal offense shall be given adequate time and facilities to prepare their defense. Your Worship, cross-examination of an individual purporting to read evidence against an accused person is part of the facilities accorded to the accused person. Your Worship, my colleague also referred to threats, which he said constitute singing. Your Worship, it is strange, because all of us sing. Even him, he was singing, yet I didn't feel threatened when he was singing next to me. But again, we note that even if he says singing is a threat, perhaps the songs that were sung were at a time when the witness was not known. So I doubt that the witness is the one who has told him that he was threatened by the voices in the song. But Your Worship, the point we also want to make is that the state has got very many police officers. And under the acts which this application is grounded, the Computer Misuse Act, and the Data Protection Act, it refers to any officer. It does not specify that it must be an investigating officer. So the state had the opportunity to invite any of its several officers. That the state chose to bring an investigating officer is clearly not the fault of the accused person who is in custody. It is therefore wrong for the state to try to recover where it slipped in this application at this stage. In any event, the identity, because I understand Mr. Billy Vumbuka to say that they want to protect the identity of the witness. But, Your Worship, the identity of the witness has already been made public in the application, which is supported by an affidavit that has his warrant card with his photograph and even number. So the information the state wants to keep private, for whatever means, is already public. Moreover, those details about the witness have been repeated by Mr. Billy Vumbuka himself here. He said the witness is a police officer and the IO. He even mentioned that his name is Odiek Benedict. So we don't want him to state his identity. We want him for evidence. So if it is protecting identity, Mr. Billy Vumbuka has already given it away. That he has done so surely means that the identity of the witness was not perhaps important to be kept private. And moreover, Your Worship, even we counsel can record and are not restricted from saying what the witness shall say in the public, because we are not bound in confidence by these proceedings. We can even draw him here and present his picture, the artistic version, into the public. That is a belated attempt to cure Mr. Billy Vumbuka's And perhaps, Your Worship, he said he wants all members of the public out. Your Worship, the first member of the public in the city is the Lord Mayor. So even we lawyers are members of the public. So perhaps by saying he wants all of us out, he wants the benefit of having the accused unrepresented, which is wrong, and he knows it. He did not say excluding the lawyers, he said all members of the public. The assumption is that for him, he's not a member of the public. Your Worship, is that Article 28(1) and 2 was rightly cited by my colleague. The emphasis is in Article 28, sub-article 2. Nothing in clause 1 of this article shall prevent the court or tribunal from excluding the press from all or any proceedings before it for reasons of morality, public order, national security, as may be necessary in a free and democratic society. Your Worship, that sub-article, that article comes after the right, the presumption being that criminal proceedings should be conducted in the public view. And Your Worship, that stems from Article 126 of the Constitution, which says that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people, in conformity with the law, with the values, norms, and aspirations of the people. Your Worship, the aspirations of the people is that their leaders must be tried in an environment where they can see that proceedings are fair. That is one of the ways in which the judiciary accounts to the people in exercising judicial power. That trials are not conducted in camera because anything can happen in camera. So before the nature of the provisions of sub-article 2 require that before the right to be tried in public view is removed, the state must demonstrate with tangible evidence that having the press and the public around is contrary to morality, public order, and national security. Your Worship, that requires that the state presents tangible evidence in the form of an application supported by an affidavit, in which it is shown that if the public remains, any of these three will result. Your Worship, it is wrong for Counsel Billy Vumbuka to purport to bring evidence from the bar that there will be national security will be compromised he has made an allegation which is not substantiated in any way. And perhaps for that matter, after our submission, before he responds, we shall, because he's now brought evidence, we shall ask that he be cross-examined about national security. So that he stops talking loosely in a forum like this one. So, Your Worship, what we are saying is that there must be tangible evidence in an affidavit. And Your Worship, we need to remember that in the most discreet society, which is the military, in the general court martial, even the public was allowed. And in the affidavit of Mr. Benedict Odiek, he says the proceedings in the court martial were handed over to the civil court. So it started as a public trial. The allegations of Mr. Billy Bubuka are unfounded. And apart from mentioning national security, which he has read, he has not stated anything about national security that will be compromised here. I want to believe that he spoke about it erroneously. So, Your Worship, to conclude, we are saying that a criminal trial is in the public interest. The interests to be balanced are that of the state and that of the accused persons and their relations. It's not the state's interests only. So taking away the interests of the accused persons must be in exceptional circumstances, which have not been demonstrated at all in tangible evidence. Mr. Bilbumka is not on oath. He's just saying things. He also said that to prevent Mr. Odiek from presenting his evidence or being cross-examined is necessary because of the accused persons involved. He's now purporting as the state to talk about the antecedents of the accused loosely. He has not brought evidence, and we don't know how much he knows about the accused persons. It's a problem of speaking loosely. So you watch, because this is a public court, and that is why we are here, and that is why this hearing was announced. This court can only fully account that this trial is in the public interest, meets the aspirations of the people, is fair and impartial, if the people from whom it derives power see it in action in real time and life. We therefore pray, before my colleagues may want to add, that the application, which is based on hearsay, is dismissed in its entirety, and we proceed with what brought us today. Because, my Lord, Your Worship shall be reminded that it is Mr. Billy Bimuka who said that this application was urgent. We shouldn't therefore put roadblocks. We should dispense with it and move on to the next level. Your Worship, my colleague wants to add something before the state can respond.
My colleague, in objecting to the application, on account of being frivolous, vexatious, and And in our opinion, it's not only misconceived, Your Worship, but it amounts to an abuse of court process and egregious abuse of court process. And I wish to substantiate. First of all, Your Worship, the state ought to have made a formal application. A formal application supported by written evidence in the form of an affidavit to substantiate all the issues they are talking about. What my colleague Frederick Mpanga is talking about. And I'm fortified in this submission, Your Worship, by the authority of the High Court in the matter of Uganda Reporters Association, Uganda Court Reporters Association Limited versus the Attorney General. It was a cause for judicial review, miscellaneous cause number 87 of 2014, where again the state had made attempts to exclude members of the press from covering criminal proceedings. And it's such an instructive decision because it brings out two critical aspects. The rights of an accused person to public justice. There is that notion of public justice, which was, I think, enunciated in that particular decision. Not technical justice, but public justice. In that case, the trial judge, Justice Lydia Mugambe, may the good Lord protect her wherever she is, quoted with approval the East African case of B4, Madrid versus R, 1960. And this is in the East Africa Law Report, 1965, East Africa, where it was held that justice should be done openly, save in special circumstances for which statutory provision to the contrary is made, and to save in certain, rather unsafe in certain other very unusual circumstances. It is better that a man should not be brought to justice at all than justice to be done to him without the public being given the opportunity of seeing it to be done. I beg to repeat this. This is the principle. It is better that a man should not be brought to justice at all than that justice should be done to him. No, it's better that a man should not be brought to justice at all than that justice should be done to him without the public being given the opportunity of seeing it done. That's how serious it is. That you had better not bring an accused person before justice than if the public will not see justice to be done. In other words, it is reinforcing the principle of equity that justice shouldn't only be done, but must be seen to be done. And must be seen by who? By members of the public. That is the principle that was emphasized in that particular case. The state argued that the accused persons will not be prejudiced, but the public will be prejudiced. The interests of justice will be prejudiced in that the dispensation of justice will not be seen or appreciated by the public, in whose name, purportedly or ostensibly, the state is prosecuting the accused person. It's an iron and a paradox, Your Worship, that the state, which is purporting to prosecute the accused persons for and on behalf of the people of Uganda, would seek to shield the people of Uganda from witnessing the proceedings. That is a travesty. Why hide the proceedings away from the people you purport to represent? It is Uganda versus Dr. Kizza Besigye and the late Mpanga. It's not Odiek. Is it Odiek who? No. Benedict. So, Your Worship, that decision is not only persuasive, but it's binding on this honorable court. The right to open justice, the judge went ahead to say, yes, in as much as it can be compromised, it's not non-derogable. Court should be cautious to look at the competing interests and the proportionality. That is the test. Competing interests and proportionality. Now, the interest of the prosecution here is to protect Odiek, not state security. And that is alien to Article 28. Actually, the proviso to Article 28, which grants the state those 3 elements. Article 28, that clause 2. Notwithstanding, nothing in clause 1 of this article shall prevent the court or tribunal from excluding the press or the public from all or any proceedings before it for reasons of morality. That one is totally out. Public order, it is out. National security. My Lord, it would, Your Worship, it would be extremely outrageous for the state, rather for the prosecution here, to be hard to assert that disclosure of the identity or the face of a police officer whose warranty card is here submitted by my land friend here, all his particulars disclosed, that it would be prejudicial to state security. Just one person like this. And for the record, Your Worship, it's not also true that Mr. Odiek Benedict is appearing before this honorable court as an IO. It's not born out of evidence. No. If we were to read the contents of paragraph 1, this is how he's describing himself and the capacity in which he deposited this affidavit. I am a male adult detective. No, I am a male adult detective inspector of police of sound mind, attached to the Directorate of Criminal Investigations in Chibuli, and I swear this affidavit in that capacity. That is all he said. He is swearing the affidavit in the capacity of a detective inspector of police attached to the Directorate of Chibuli Criminal Investigations. It's only in paragraph 4 where he faintly brings in the issue of being part of investigation, the investigating team. That Uganda Police Force took over the investigations of the case on the 11th of February, and I was one of the officers assigned to investigate the case. One of the officers. He's not the one leading the investigations. He's one of the very many police officers at Chibuli who are investigating this matter. He didn't in any way insinuate that he is a key person, the central person, that every investigations, all the investigations hinge on him, they rotate around him. Nothing. The impression that was being created. And then in paragraph 6, it said, as part of the investigations, we received some items, blah, blah, blah. Your worship, I don't know whether, because if this application is granted, in essence it means the entire investigating team handling this matter will be had in the camera. Because each of them will claim to be under threat by public attacks, because that's all we had, that they will be attacked by the public. A police officer who's supposed to move in a uniform with a name tag, because even if he goes into camera there and we go into chambers, look at the absurdity with this. He's already within around this place. Even if the members of the public are excluded, they remain here. We retreat to the chambers. After the proceedings, he will walk out, and the cameras will be here waiting for him. Members of the public will wait for him and say, here is the man who has been in the chambers. So what does that mean? So this is why I said, Your Worship, this is a frivolous and vexatious application intended to waste time of this court. We would be doing something else now. We wouldn't be indulging in all this. So we pray that Your Worship will be pleased to dismiss it with all the contempt it deserves, and we proceed to the next stage of the application.
Can you rejoin Your Worship? My senior colleagues said a lot, but had just a few things to pick out. Because whatever they said at one point was redundant. I'll start with what my senior colleague Lukwago said, the last one. He has alluded to that authority, actual authorities. Whereas it would have been a very good authority if this matter was under trial. And I would entirely agree with you. Unfortunately, the facts in the authorities he cited are completely inapplicable to this matter. The authority my senior colleague cited emanates from an application that was filed and had by the judge or the justices who were substantively hearing the matter. Your Worship, this is an application which relates to investigations, not the substantive trials. So the two do not speak to each other. And Your Worship, you are not bound by a precedent which is inapplicable to the matter you're handling. And we invite you to consider it redundant. It is good that our senior colleagues, especially Senior Counsel Lukwago, appreciated the fact that Mr. Benedict is one of the investigating officers. He ought to have withdrawn the first statement, but I think he by implication, withdrew it, where he had strongly stated that he's not an investigating officer in that matter. But with seniority, we shall not most of it. So, Your Worship, Mr. Odiek Benedict is an investigating officer in this matter, and he ought to be protected by this honorable court, because this matter is not under trial. I would have agreed with my senior colleagues if this matter was being heard substantively. It is not the respondents to choose for the applicant who to be the main investigating officer. And we are not obliged to make it categorically clear in any of the affidavits that Mr. Odiek is a key investigating officer. Merely mentioning that he is part of the investigative team is enough. This application is not in any way an abuse of the process. Unless my senior colleagues have argued in fact that they are arguing that Article 28 Clause 2 is unconstitutional. The provision is here. And a good lawyer is one who knows where to find the law. This is the law. This is not Bill from Bukarashadi Act. This is the Constitution of the Republic of Uganda, to which this court subscribes. Your Worship, it doesn't matter whether the press is going to wait for Mr. Odiek, unless that is a planned thing. And this is what we are arguing. Good enough defense, counsel for our respondents, are clearly making it clear that they are looking forward to identify Mr. Odiek. That is enough evidence that they are going to look for him and know who is this investigating officer. Our argument is that that alone constitutes.
Your Worship, sorry to object, but just want to advise my colleague. Submissions of counsel are not evidence. Surely he knows that.
That's why I also remind my senior colleague that when he was attacking and mentioning Billy from Kabicha, it was wrong, because Billy is appearing for the applicant.
Let's stick to the substantive.
Most obliged. Most obliged. We are here respecting senior counsel. My senior colleagues alluded to the fact that the public by excluding the public from this application, their rights are going to be violated or prejudiced. The right to be present in court. But at the same time, my senior colleague Lukwago answered himself for the respondent that being present in court is not one of the absolute and non-delegable rights. He mentioned, actually, he submitted and answered himself. Your Worship, the public's presence in court, in any trial, is not one of the non-delegable rights. And that's why Article 28, Clause 2 says they can be excluded from the trial. We just try, Your Worship, to paint a picture that if the Constitution suggests that the public and the press could be excluded in the substantive trial, how about this application, which is emanating, or which is intended, or which is part of the investigations? I think this is the best time for court to exclude the public and the press, because then they will have then the right to be present at the time when the substantive trial of this matter is on. The substantive trial. This is not a substantive trial. Your Worship, prosecution mentioned Mr. Diek Benedict because the defense mentioned his name in the first day when he said we would like to have Mr. Diek Benedict to be present in court on the very first day. If my senior brother could memorize that. And that's why we were able to speak and mention his name. Your Worship, it is not true that the respondents are addressing this court loosely. It is the defense. It is the defense. In any case, what we are here for would have been here basically for retention. Otherwise, applications for access, imaging, those are expired. So, it is something, Your Worship, that this court can
Worship, we did not talk about the nature of the application being inter partes. But again, if my colleague reads
Section
31 of the Data Protection Act, you will find that it is an application which is inter partes. So again, to correct you.
Your Worship, it is a minor correction. Your Worship, my senior colleague Mpanga tried to address this court in respect to the authority that we relied upon. The Sun Yen King Kong Congo King case. My senior brother also hid away from court the fact that court was on record for mentioning the issue of protecting witnesses and evidence. And it gave exceptions under which that can be done in the same case. I agree with him that the principles therein were emanating from an application by prosecution who did not want to disclose. However,
Your Worship, sorry, the principles emanated from a constitutional reference. My colleague is lying. It was a reference from a trial before the Honorable Our Worship Stella Anabilis in the Magistrate's Court at Uganda Road, a reference made under Article 137(5)(b) of the Constitution of the Republic of Uganda, where the state had refused to make a disclosure prior to the accused person taking plea. The state in that case did not apply. It was a respondent. It was counsel who applied for the disclosure. So the state has never applied. It is important that counsel is truthful, or we shall ask him to submit on oath.
I think the issue was about disclosure, which we have mentioned. I think my senior colleague still wants the microphone, but we shall keep sitting down and the addresses court. The issue was about disclosure, which we say everything.
Proceed,
Your Worship, it is therefore this court's duty to protect Mr. Dick Benedict and the integrity of the investigations from morality and public order, and also national security.
Say that again. Protect it.
The reason why the public and the press, the reason why the press and the public are excluded are for three reasons: morality, public order, and national security. I think, Your Worship, that marks our agenda. We invite this court. We invite this court, Your Worship, to allow the application. So,
This is the decision. Having heard from all parties concerned, this court takes cognizance of the fact that this is an application arising from the investigations in the murder file, wherein the two accused persons are charged with a capital case, and not a substantive hearing of the said capital matter. Court is also alive to all the authorities that both the state and defense have alluded to, and agree with the defense that they are binding on this court. However, this would only occur if the facts/circumstances were similar, which isn't the case, and therefore not binding in this matter before court today. Yes, an accused person is entitled to a fair, speedy, and public trial, and the exception to public trial being for reasons of morality, public order, or national security. In the case before court, given the nature of the charged offences and the fact that the matter is still at investigations level, it's only prudent that for the integrity of the investigations to be upheld, so that morality, public order, and national security can be maintained, that this application be had in camera, as no person, that is the accused, and public, shall be prejudiced in any way, given that since it's still at investigations level, when the investigations are complete, full disclosure as provided for in the monuments in case can be sought and used as wished by the defense. So the matter is going to be heard in camera in the next 10 minutes.
We have an application to make, Your Worship. We have an application if you. Your Worship, we appreciate the ruling of this Honorable Court, but we have instructions to apply for revision of your decision before an appellate court. Your Worship, under the provisions of Section 33 of the Judicature Act, Section 48.
Section what?
Section 33 of the Judicature Act.
Yes.
And then Section 48 and 50 of the Criminal Procedure Code. Probably we are also adding Section 17(1) of the Judicature Act. It's both Section 17(1) and 33, as well as Section 48 and 50 of the Criminal Procedure Code Act, and Rule 2 of the Judicature Criminal Procedure Application Rules, which grant the right to an aggrieved party in any matter to seek for revision of any order made by this Honorable Court. So we also pray that Your Worship, the applicants be granted, rather the respondents be granted their right to seek for the remedy at an appellate court by way of revision. And we pray that you be pleased, Your Worship, to stay the proceedings until the application is disposed of. We also pray that Your Worship, this Honorable Court provides us with a typed record of proceedings, the ruling itself, and the entire certified record for that particular purpose, Your Worship. Your Worship, this application, in our opinion, goes to the root of the dispensation of justice, and it's a grave concern to us that, Your Worship, if we proceed in this manner, there is likely to be a miscarriage of justice. As you have observed in your ruling, Your Worship, that we are at a very critical stage of gathering evidence. And if there is any non-compliance with the procedures and all the rules guiding investigations and evidence gathering or assembling the evidence against the accused persons, it will be highly prejudicial and it will occasion a miscarriage of justice. So we pray that that importance be appreciated by this Honorable Court, and our prayer is granted. So the emphasis is on Section 48, power of this court. That is the High Court to call for a record and have it reviewed or revised for appropriate orders to be made. We do so for Your Worship.
Your Worship, we prefer stand over in this matter for a response. Yes. We prefer stand over.
You have 30 minutes.
Most obliged.
Okay.